My name is Tanveer Muhammad Masood, and in this YouTube video I'll be talking about several amendments and several modifications and changes that have been brought about by the new Companies Act, the Companies Act of 2013. So prior to this, I basically discussed and talked about section 261 to 48 and other such relevant sections which are basically associated with the maximum number of companies in private companies, and section 455 which basically deals with dormant companies. So now I'll be talking about another one such section where a minute modification has been done, and that is basically section 560, which deals with winding up of a company. Now, section 560 of the Companies Act 1956 basically deals with winding up of company, and it provides that there needs to be 3 modes of winding up when a company is getting liquidated and getting wound up. There are basically three ways of winding it up, and first and foremost is voluntary winding up by the act of the company itself, by the creditors, by the registrar, or by the tribunal or the court for that matter. Now, the change that has been brought about, or the modification that has been done, is that this Companies Act of 2013 basically states that there are only 2 modes of winding up of a company. Only if the tribunal or the court steps in, the company can be wound up, or the act of the company itself, that is called the voluntary winding up of the company. So this is the minor difference that we've noticed in section 560 of the Companies Act, and the new Companies Act, as I said just now, that there are only 2 ways of winding up of the company as compared to 3 ways or 4 ways, to be more precise, of winding up the company provided by the Companies Act of 1956. Moreover, as per the Companies Act of 2013, if the Company Law Board or the tribunal steps in, then the Company Law Board or the tribunal would basically consider the fact that the company has not filed its annual returns, financial statement for 5 consecutive financial years. If this is the scenario in any given company, then basically the court or the law board has this jurisdiction and authority to order the winding up of the company. So this is another modification that we would notice in the Companies Act of 2013. So if I could summarize this, as per the Companies Act of 1956, there are basically 4 ways of winding up of a company: voluntary winding up by the act of the company itself, by shareholders or creditors, by the court or the company law board or the tribunal, or by the registrar of companies. So there are basically 4 ways of winding up of the company as per the Companies Act of 1956. Now, with the advent of Companies Act of 2013, things are pretty different. What we notice under the Companies Act of 2013 is the fact that there are only 2 modes of winding up of the company. First and foremost, National Company Law Board Tribunal or the court can step in, and secondly, by the act of the company itself, or we can call it voluntary winding up of the company. And the company is basically getting wound up by any interference or by the act of the company law board or the tribunal, then the tribunal basically considers the fact that the company has filed its annual report or annual return for the financial statement for 3 consecutive financial year or not. This is the most important evidence or rather the most important thing that the law board or the tribunal would be checking out whether the company has filed its annual return. If it has filed, or it is consistent in filing its annual return for the last 3 consecutive financial year, then there won't be any sort of problem. There won't be any winding up of the company. But if the law board or the tribunal finds that the company has basically been inconsistent in filing its annual report of financial statement for the last three consecutive financial years, then we basically would take into account this fact and may go ahead in winding up of that company, and ordering the winding up of the company for that matter. Another important point the company law board or the tribunal would basically uh, consider is that whether any sort of order has been made under the revival of Sikh and rehabilitation of Sikh companies, revival of Sikh companies or rehabilitation of Sikh companies as per Chapter 21 of the Consent Act. So this is another point that the court is going to consider. The third point or the third evidence that the law board would consider the fact that whether any notification has been or any application has been made to the registrar for winding up of the company. If the law board or the tribunal finds that an application is pending with the registrar of the companies for winding up of the company, then it would basically consider that fact as well in ordering winding up of the company, or rather in ordering the liquidation of the company. So these are the basically different things, different evidence and points that basically be taken into account for winding up of the company. Again, the company law board and tribunal steps in. So if I could summarize further, the difference between the Companies Act of 1956 and Companies Act of 2013 as far as winding up of the company is concerned is that the fact that there are only two ways of, or rather two modes of winding up the company provided by the Companies Act of 2013. First and foremost mode is the fact that the company law board or the tribunal can step in. Firstly, secondly, the itself or the owner of the company itself can basically go ahead and file an application to the registrar of companies for voluntary winding up, which is called voluntary winding up of the company. So these two methods are basically available under Companies Act of 2013. And when the tribunal acts, it basically takes into account the fact that whether an application has been made to the registrar of companies for voluntary winding up of the company or not. Secondly, there any notification or order has been issued under Chapter 21 of the revival of Sikh and rehabilitation of Sikh industrial companies. So the last but not the least point that the law board is going to consider is the fact that the company has been consistent enough in filing its annual report of financial statements with the ROC or with the registrar of companies for five consecutive financial years. This is another important point that the company law board or the tribunal is going to take into account. So all in all, there are basically minor differences between Company Act of 1956 and Companies Act of 2013 as far as liquidation or the binding up of the company is concerned.